Thank you, Jess, for the introduction, and thank you, NGFA and the Grain Journal, for the invitation to join you all again this year. This is one of my favorite events of the year. I get to spend time with the folks at OSHA in this region who do a great job, especially now with that alliance. I think it's been a great development for the grain industry, and get to spend time with a lot of my friends in the grain industry talking about things that I enjoy: OSHA inspections, OSHA enforcement actions, and ways to improve safety and health in all of our workplaces. I'm particularly pleased to be joined today by Tom Bielema. Tom and I sat across the table from each other quite a few times when he was the area director in Peoria, Illinois, but always had the same goal in mind and accomplished a lot of great things together in that regard. Unfortunately, Tom has been cured and he's come over to the other side of the other side of the table now. Just a joke for my friends at OSHA, but have had an opportunity to work with Tom in his new capacity as a consultant. He's doing a great job in that regard as well. This program today is intended to be interactive. It'll be interactive between Tom and me, where I'll share sort of the employer side, council side perspective on OSHA inspection issues. Tom will share both sort of the OSHA side in his former capacity as an area director and also as a consultant and as a private sort of running safety programs for a private employer as well, but also wanted to be interactive with all of you. So in this part of the program, I'd encourage you to ask questions. I think during the presentation as we go along, if you have questions or if you have sort of anecdotes or experiences that you've had during an OSHA inspection that fits in with what we're talking about, I think it would be very interesting for the rest of the group. So any introductory remarks?
Yeah, not to kiss up too much, but an honor to see the OSHA folks again. They do a great job. I'd be the first one to say I spent 23 years there, so if I told you I didn't like the agency or what they did, I'd be a fool to stand here and tell you that. It was a great job for me. I'm only 45. It was time for me to make a transition. I didn't get run out of town. I'm not old enough to retire, but it makes me feel better than saying I quit. So I just needed something else to do. I love being a safety and health practitioner. OSHA gave me that opportunity to do that, and it's an honor to be here. I appreciate the stand-up. I appreciate the alliances and things like that because I love being proactive. I love being able to deal with things before they become an issue. So we're going to talk about inspection. We're going to also talk about culture and things like that because what I'd love to have you do is your house is in order. When they come in, it's a hearty handshake, the warm glow of a job well done, and they leave quickly. That's what you're looking for, and that's because your house is in order, your folks are safe. I love working with Conn. I hated him when I worked across the table. He's a great guy. He's a great guy, great attorney, very progressive safety and health guy. And as he said, we always had the end goal of wanting to have the folks safe at work. So when we talked about money and citations and penalty and classification, those kind of things, he was very challenging to work with, but he was really good, and I knew that. So it's a great opportunity to work with him again. NGFA and the folks, just honored to be here, and that's enough of that for me. You can see our bio and things like that, but I think the value of me being here is, as Eric said, he's going to be from the legal perspective, and he's a great lawyer and does that thing. I'm a safety and health guy, but I've been on the other side of the curtain, so I can tell you what it looks like, right? So I can tell you what they're looking for and practically, kind of manage what that inspection is going to look like. When they show up and knock on the door, they're going to be there, but maybe I can help you from the other side of the curtain and do that as effectively as you can. So I think what we're going to do today, we're going to start with why it's important to manage that inspection, what your inspection rights are for you as the employer and for the employees, right? We're going to talk about anti-discrimination, and Ms. Stilley talked about some of that. We're going to talk about that a little bit more. We want you to know how to prepare for that OSHA inspection, because if you start preparing at the time that they knock on the door, you're going to be behind the curve. It's going to move pretty quick, and as I would say, that'd be like getting a drink from a fire hose. It's going to be coming at you really quick, really fast. And so we want to give you some tools that you're able to look at forecasting that. They have an emphasis program. The spot the industry's in. You need to be prepared for that. Then we're going to help you manage the ongoing inspection. We're going to help you do that all the way from the opening conference through the settlement negotiations. And then finally, what do you do post-citation? And the post-citation issuance, what are going to be your options and what's your best play there?
All right, so the why it's important to manage an OSHA inspection. I can tell you that the day after this last presidential election, I woke up as a regulatory defense attorney and said, holy crap, what am I going to do now? They're going to abolish OSHA. There's going to be no role for an OSHA defense lawyer. How do I reinvent myself at this stage of my career? That was sort of the expectation, right? You listened to what was going on during the campaign, and it was all about deregulation, Deconstruction of the regulatory state was a phrase or a concept that the Trump campaign talked about a lot. So, reasonably, there was an expectation that, boy, things are going to change dramatically over at OSHA, at least from an enforcement standpoint. As Kim talked about, though, the reality has been a little bit different than those expectations. I go every year to the American Bar Association. There's a division of lawyers who practice in this field of safety and health, and it's attended usually every year by folks from the National Office of the OSHA solicitors and other folks from the agency. And this year everybody was paying careful attention to say, how different are things going to be at OSHA? What's our expectations going to be? And what I was hearing in 2018, after a year of the Trump administration was in effect, sounded an awful lot like the first year of the Obama administration. There was, it wasn't quite the new sheriff in town talk, but there was a lot of talk about, hey, OSHA is an enforcement agency, and we're not going to back away from that enforcement mission that we have. There was talk, like Kim said, about the balance between enforcement and compliance assistance, but that's always been there. So we said, okay, we're hearing from the senior leaders at OSHA, and they're saying really not going to be, you don't expect to see a whole lot different. And the reality in some of the things that OSHA has been implementing has borne that out. You want to talk about the emphasis program?
Yeah, so we're going to continue with similar to the Obama administration when that was there. The number of local, regional, and special emphasis programs, that's really not changing too much. The 9 national emphasis programs are going to stay consistent. Again, OSHA's intent with these is if you do the work to these and you see the impact in the industry, and I'm a big proponent of the compliance assistance portion of that up front. I love to train people. I love to pass that on, and then it's the Ronald Reagan, trust but verify. We're going to go check, right? But when that works and they see those numbers declining, they see that it made impact, theoretically, these are going to come off there. There's some of the older ones like trenching and excavating that have been there, I think, since '89, maybe something before. I was still in high school at that time, but it's been out there. The reason it's still there is because the impact hasn't been made. They're still seeing the injuries and illnesses and the fatalities there, and they know there's still work there. But these are going to stay. These enforcement programs are going to stay there. You're still going to see special emphasis and regional emphasis programs reacting to injuries and illnesses, fatalities, significant events that are happening in one's jurisdiction, and you're going to see those continue. And I don't think with this administration that you're going to see them back off that. So that gets us to the grain emphasis program. So FY18, I think you still see it in 5, 6, 7, 9, or 8, and 10, which is pretty consistent the way it's been. And as Ms. Stilley talked about and showed the data, fatalities, there's still some fatalities out there that they want to eliminate. There's injuries and illnesses. There's willful and repeat citations. They're going to continue to work on this until they get that down to a manageable level or until they get that to that goal of 0 injury, 0 fatality, and they'll continue to work on you. So I think you'll continue to see that as we go forward.
I always see these are, they're outdated. Like it says renewed in 2016, but they're for a fiscal year, correct? So how come oftentimes they're not posted, or if they are posted, it's delayed? Is there a reason behind that? I mean,
well, so
the Cardinals lost last night. And,
so I can tell you what, I went to research this. I had an old slide from sort of this presentation 2 years ago.
I have the same thing. I do the same thing, and I keep looking for an update.
But I think we looked at all these, and we were able to find on OSHA's website, none of these have expired yet. These were the last renewal dates. I think sometimes it takes time to get stuff on a website, but by and large, these are current. None of these have expired. It looks like a whole bunch of them are about to expire, but we presume they'll be renewed again. But yeah, I've seen some where there's an older version of it, especially when there's no meaningful change to the program itself. It's just a new date.
Right. And they are, presently, when Tom was with the agency, emphasis programs went year to year, fiscal year, fiscal year, fiscal year. And there is talk now, there's a talk of extending the emphasis program so it doesn't have to be renewed on an annual basis, but move to, like similar to Alliance's, 2 years, 3 years, as long as the data can justify it's a current trend, similar to, the trend is continuing.
Yeah.
So I fully expect these to be, as Eric said, re-upped, maybe longer.
Yeah.
And the only scope I can tell you is from the southern 81 counties of Illinois, so I-80 South. this is a difficult burden. You know, towards the end of the year, you got a lot of things coming. You got to wrap up a lot of data. It's got to get to the regional office. The regional office will then apply for the next phase. So some of these that are lagging behind is just a matter of getting through the process. But again, not reflective of the agency, SCT, or anybody else other than this guy here. I would expect to see these continue with the way we've seen them.
And there have been some changes. I think there are some regions that used to be region-wide that have gone down to maybe just individual states. And when you see those big changes, you know, they're pretty prompt to get those directives out. But if it's just to slap a new date on it, sometimes it takes a little bit to get up on the website. But by and large, they're operating the same. The theme here is, hey, if you expected a big difference from the Trump administration, look, the more things change, the more they stay the same.
And that takes us to this slide. So this is grain industry inspection data. And again, you know, we can break this apart by different national or NAICS codes or SIC codes. But ultimately, what we were seeing through 11, 13, 15, 17, we picked the odd years because it was good for us. But the number of inspections, you know, has declined. The number of violations issued has also declined. So that's a positive thing for the industry, right? If the inspections are still out there, maybe there's more in compliance. Maybe there's more non-inspections there, but it's not going to go away. It may decline, and again, the point would be that they worked themselves out of a job. I got up and shaved every day when I went to that job, hoping that, hey, nobody gets hurt today, no hazards are there, and pretty soon they're going to look to cut my staff because we've done a good job to get there. And again, I think that's a really tall order, and I know a lot of folks have worked in a long, very illustrious career and worked very hard to get there, but you'll see these continue to decline.
So some of the other, you know, angles where you might expect to see, all right, well, there's this new administration that is anti-regulatory, deregulatory focus. Surely the budget's going to get slashed over at OSHA. And the reality is, I mean, looking at the 2017 enacted budget was really President Obama's last budget. The number of FTEs at OSHA, the budget over at OSHA, it's within the margin of error, exactly the same last year and exactly the same as what it's likely to be in 2019. So if the expectation was that OSHA is going to suddenly ease up on employers, we've not seen any evidence of that in terms of the resources that the administration is putting to OSHA, in terms of the, you know, conduct of the agency in implementing emphasis programs, conducting inspections, and all sorts of manners. I mean, this one is fascinating to me. In the out years of the Obama administration, the gross number of inspections was declining. There's good explanation for some of that. The agency changed the way it evaluated and tracked inspections and started to assign value to more intensive inspections. But in terms of, you know, show up, present their credentials, and conduct an inspection, the numbers were going down every year. The first year of the Trump administration, it ticked up for the first time in a long time. That's, you know, probably not the direction that we expected. After the election and all the talk about deregulation, we're actually seeing a few more inspections. Penalties, the penalty authority at the agency continues to go up every year. And this was something that was a deal brokered in Congress during the Obama administration that triggered an automatic annual increase in civil penalty authority. You know, as the consumer price index climbs up every year, so too will executive agencies' penalty authority. Well, we've got a Republican in the White House, Republican control of the House and the Senate. You know, there was an expectation perhaps that was going to change, that they were going to eliminate that automatic update. That hasn't even been proposed, so far as I can tell, in either house of Congress. And so every year, penalty authority goes up. It's now up to almost $13,000 per violation for other than serious and serious, and almost $130,000 per violation for willful and repeat. And they're using that authority. Like, how many people here, raise your hand, who thought that OSHA would set a record for most $100,000 fines under the Trump administration? I was not in that group. I don't see too many hands going up, but that's what happened. And largely that's because the penalty authority has gone up, but they're using it, right? There's really not been a change in suddenly cutting the percentage of the maximum fine that can be issued to an employer. That hasn't changed. The way penalties are calculated hasn't changed in any significant way. And all of a sudden, in 2017, the agency set a record for the most $100,000 total enforcement actions that were issued. So we're not going the way of, you know, disappearing enforcement under a Trump administration. Regulation by shaming. This was a very interesting category, right? The enforcement press release. There were, historically, and this is not a new tool that was invented during the Obama administration, but this is a quote here from David Michaels, who is the longest tenured Assistant Secretary for OSHA, and he was basically the entire Obama administration, says, in some cases, regulation by shaming. That was his term, not mine. Most people think that's my jaded defense lawyer's expression for these press releases. That was OSHA's term. Regulation by shaming is the most effective way to encourage a reduction of hazard in the throughout industry. And the idea is, with a single enforcement action, let's leverage each enforcement action by putting out a press release to notify the rest of the employers in the industry, here's what could happen to you. And during the Obama administration, the number of press releases that were issued skyrocketed. It went for, almost tripled from the number of press releases that were being put out during the Bush administration. The other big change was that they used to be very just sort of black and white factual, company received citations, total penalty of X, they've got 15 days to contest. During the Obama administration, those press releases, 100% of them included a quote, usually inflammatory, embarrassing quote about the employer in conjunction with the enforcement action. Then all of a sudden on January 20th, the day President Trump was sworn in, the press releases stopped. There were 0 of them. We said, okay, well there's a big change in the way OSHA operates from the prior administration. And then on April 28th, which is the day that Secretary Acosta was sworn in as the Secretary of Labor, and as Kim said, he's a believer in the mission, right? And so he says, the career folks at OSHA said this is something that works. It's something that people pay attention to in the industry. We should do it. And he said, okay, let's do it. And it looks more or less like the way the Bush administration was doing it, the frequency of the press releases. But the big difference is they continue to have those quotations. So you've got sort of a blend of the Obama and Bush regulation by shaming policy in effect right now. I'm still trying to understand how it works, what the threshold is for a press release, because we've seen some big actions that didn't get a press release and some little cats and dogs that do get a press release. So I'm not able to sort of articulate what the policy is right now, but I know that they're happening at a pretty consistent rate with what we've seen in prior Republican administrations. So really no major change there either. The Severe Violator Enforcement Program, still out there alive and kicking. It's, again, something that the new administration, now a year and a half in, has not revisited at all, hasn't changed how you qualify, how employers that get put into the program are treated, and it's still out there sweeping employers in on a regular basis. And I've highlighted here in big glowing orange, the grain industry, the grain handling standard continues to be one of these high emphasis hazards that if you are cited for multiple repeat or willful violations of the grain handling standard, you will be dumped into the Severe Violator Enforcement Program. You get multiple inspections, follow up where the original citations occurred, and perhaps sister facility inspections, particularly bad press around those enforcement actions, as well as some sort of heightened requirements and settlements like corporate-wide elements and things like that. So the grain industry does continue to be, unfortunately, well represented among the ranks of severe violators, but this is a program that was born during the Obama administration, a year and a half into the Trump administration. I've not even heard any discussion at all about this being revisited. So again, perhaps our expectations are being confounded. So that's a lot of reasons why, hey, if you think you can relax now that OSHA is somehow not going to, come knock on your door and they're not going to be, a serious enforcement agency that you don't have to worry about anymore, the reality is that's not the case. So it is as important today as it was 2 years ago to prepare for an OSHA inspection. And then, again, the reason why we do things the right way in the grain industry and in every industry and the clients that I work with is to protect our employees. Today we're talking about this regulatory concept, right? An OSHA inspection and possible enforcement action. So we're just talking about why it's important from a regulatory standpoint to prepare for the inspection. There's a lot of good reasons to prepare. Even if OSHA did disappear, there's plenty of good reasons to do the right thing in the workplace from a safety standpoint. And Tom will talk about some of the good things that you can do.
Yeah, so like I said, I'm a safety and health guy at heart, so I had to talk about this a little bit. We're going to talk about managing the inspection and all the ins and outs of doing that and what it's going to mean if you get citations and how we do that. One of the things I got to talk to you about is preventative, right? You want to keep them out of your house, you're going to have your house in order, right? So in 2015, if you had an amputation, if you had a work-related injury that resulted in hospitalization or loss of an eye, you're going to call them. Guess what they're going to do? I mean, I can tell you, and it's not across the board. There's a triage document, and you can look at the directive from Washington D.C. that's going to talk about how they're going to do that. I can tell you my theory of where it was, and I told Eric this last night at dinner. If there's a body part laying on the ground, everybody in the facility and everybody anywhere would think, hey, that's when OSHA should come out. Right? If there is a finger, an arm, or whatever you want to talk about. If somebody got hurt bad enough that the ambulance had to take them to the hospital and they had to stay there, when should OSHA be there? That's another spot, right? So we made every effort in my jurisdiction, we made every effort within resources to be able to get out there on those kind of things. And again, so one of the things on being preventative is to not have those significant events and to not have injuries and illnesses. And so one of the ways to do that, and one of the biggest things I've seen within the industry, and again, I'm not trying to get too preachy, and the other thing I'll apologize for is I'll do 80 words a minute with gusts to 120 at times. So I'll try and tone that down. But when we talk about safety culture, we got to change the way we do it, right? A lot of times in the industry, and this has been my experience over 23 years, that's just the way we do it. That's just the risk we take. That's what we know. That's what we do. That's what I've been taught how to do. And we got to change that. The biggest thing is going to be safety culture. You can go to Wikipedia. You can go to Webster. You can go to wherever you want to find your safety culture definition. But whether it's the attitude, beliefs, perception, values that an employee's going to have, or you're going to go there and just say, hey, this is the way we do it. Safety culture is something that you have to change. And when I look at that picture there, and I know it's hard for some of you to see, this is the greatest picture for safety culture because you can't see from there, but there's 8 people involved in that ridiculous thing right there, right? So the big truck can't it can't get to the reach it needs, so they put another truck on there. They're finding a way to do it. We're racehorses in a closet, want to get to work, want to make sure we can get the job done and we can make money. But there's 8 people involved in that. So which one's to blame? All of them, right? That's the culture we need to change, and it's not tattling on your coworker. I know some of you work in areas where you might have some embedded, fathers and sons and son-in-laws and brother-in-laws and things like that. It's not a tattletale type thing, but we got to change that culture because people can get hurt. Next slide, please. So the reason we do this thing, right, the evolution of, and we've got a longer presentation at that, and I tried to cut this down because, again, I want to land my plane with you. It all started out with be safe, right? It's Hill Street Blues, be careful out there, right? And that's the way we started. And a lot of you in the room, that might have been the way you learned in the industry, was be careful. That auger's turning, right? Don't step in it. Don't put your foot on it, right? And some of the perception of the hazard is going to be a big part of that. So we've moved that down the evolution of this. We started making work rules. And with that, then we trained employees on what those work rules were wanting to be. And we're looking to be OSHA compliant. Right? Looking to be OSHA compliant. As Ms. Stilley said, that's the minimum a lot of times. Some older, outdated standards, but that's the minimum. We need to push that to the next level. The biggest thing I loved out of the Obama administration, again, this didn't get a lot of publicity, I loved this I2P2, and I'm not a big Star Wars fan. This isn't some little robot or anything. I2P2 meant Injury Illness Prevention Program, right? I2P2, and what I loved about it was in its intrinsic base was find it and fix it. I'll take care of my own house. I don't need OSHA to come in and knock on my door and tell me there's a guardrail off my truckload platform. I don't need them to tell me that I shouldn't get in the bin with this material hanging up on the walls and things like that. I can find and fix my own things. I love that about I2P2, and I want to motivate you to make a program that looks like that. Safety and health management system is the key to that. And that will help you progress to those voluntary protection, whether it's SHARP, VPP, ANSI, one of the ISO programs, any of those to say, hey, we're above and beyond. But again, we can fly our own plane. We don't need intervention from somebody else to tell us how to do it because you guys at heart want to keep your employees safe. You want to keep your resources protected, and you want to be a good corporate citizen. You don't want your name in the paper. You don't want the press release because if somebody sees a grain elevator on fire, you know what? They don't know whose it is. They just know somebody in the industry. There's another thing. They see it in the paper that somebody got entangled in auger. There's another thing, right? So you're telling people this is where I work. So we can move this along. Next slide, please. So the safety and health management system, the core elements, this leads to VPP, but management's got to be committed and you have to get employees involved, right? Your safety and health committees, you got to get folks involved. You got to make sure that you're doing your worksite analysis. That's your find, right? And then we go to the fix. We're preventing hazards, we're controlling those, and we're moving those along. Training and information, a lot of the folks don't have the same common sense or the same knowledge that you might have had, right? So you have to instill that in them. You have to tell them this is the way we do it. You don't know where they came from or what they knew. You want to make sure they know it, especially your temp employees and your seasonal employees that may help you. And then the last thing is never be happy with just where you are. Always look for continuous improvement. Always be looking to go to that next spot. And that picture, if you have to say, dude, hold the ladder or dude, hold my feet, you're doing it wrong. Okay? That's just Tom's theory on that. And then the last thing, and again, I can talk to you about shims until my face turns blue, but again, those key elements of safety and health management system, what we're looking to do is change that gap. This is where we are, this is where we want to be. How can we shorten that gap? How can we tighten up the things? And on those slides, you're going to get a copy of them. I'll bear you of going through all 12 of them, but those are the great spots that will help you push your safety and health program forward. If you haven't started yet, find a place to start. There's consultations program, there's consultants, there's folks that can help you, but we want to move you from point A to point B and shorten that gap. Okay, so that gets us to the inspection. Okay, so you did all that, you're ready to go. OSHA comes knocking on the door, right? So that's what you guys came here for today. You want to hear what the OSHA inspection is going to look like. What we're looking to do to help you today, next slide's fine, is control that. I guess this is Eric, sorry. I get on a roll, I apologize.
Before we get into sort of the mechanics of the inspection, the different stages of the inspection, and some tips and strategies for how to navigate through that, it seems to me the best place to start to think about how do I effectively manage an inspection is what does that even mean? What are my goals during the inspection so that I know what it is that I'm trying to manage to? And the first one, and really this one sort of guides almost everything else in the process, is control the flow of information. And it's control the flow of information when it is provided, in what light it is presented in, and obviously the objective is to present your workplace, present your safety program in the best possible light to the agency, to the regulator who's evaluating it against the compliance requirements. So we'll talk about how you control the flow of information. It's not about hiding things under the rug. It's not about getting the shredder going in the back room when OSHA knocks on the door. It's about presenting things in the most positive light and presenting it at the right time during the inspection, whether it's promptly so that OSHA knows that you're cooperating, or at the right sort of sequential stage so that it presents the right picture of what your safety program is all about, that you're presenting the right data set so that it is clear that you have everything that's required under the standard, and if you go beyond the standard, that you're presenting those things that demonstrate that you go beyond the minimum requirements of the standard. And it's all about sort of managing that relationship with the agency, managing how you respond to their requests, whether it's documents, interviews, or the walk-around process through your facility, to control and to be able to present your workplace and your safety program in the best possible light in the process and the sequence that you think makes the most sense to accomplish that. Minimizing business disruption is a part of this. An OSHA inspection can be a big burden, right? If you're a relatively small employer and OSHA comes in and they want, this list of 25 items of documents, and they want to interview 5 or 6 employees, well, that's going to keep a lot of people from doing the job that they're otherwise supposed to be doing. And if you are depending on everybody to accomplish one part of the process to keep your business moving the way it's intended to move, pulling people away to grab documents, pulling people away for interviews can be disruptive. And so you've got to find a way to manage that process. And some of this, goes hand in hand. The flow of information to OSHA may well be impacted on how much business disruption you can tolerate, or how much business disruption will actually occur if you pull people away to do the things that need to be done to respond to OSHA's requests. So you want to manage those two things hand in hand and have a discussion with OSHA about that. I mean, these folks are reasonable people. I've rarely encountered a compliance officer that I couldn't talk with and negotiate with about sort of, hey, listen, I know you want to interview these people, but he's involved in loading a train right now. Can we just get that train out the door and then set the interview later this afternoon? if they don't detect some sort of nefarious purpose, and there shouldn't be one in your intent there, they're going to work with you. But you've got to figure out when it is that it's important to make that request, when it's important to you to make that negotiation, so that it's not going to impact how your workplace and how your safety program is presented, but work with the agency and manage those two issues. Casting the workplace in the best light, we've talked about that, and we're going to talk about that a lot through the rest of the program. And then the last goal I think we should have during the inspection process is identifying problems early. Preferably, you're identifying the problems before the agency does and you can address them, but if that's not the case and you're identifying it sort of hand in hand with the agency, you can show a lot of good faith by jumping on those issues early, addressing them, and sometimes they won't even turn into citations. If they do, sometimes the characterization will be different, your abatement obligations will already be addressed. So you want to identify those problems early. Often it's a perceived problem. This is one of the things that you want to understand. Has the compliance officer perceived that there's a compliance issue? And if you can pick that up early enough in the process, you might be able to address that perception by providing additional records, by putting the right person in front of the agency to describe either a physical task that's performed or describe a program that the compliance officer has some concerns about. So identifying real problems and identifying perceived problems early in the inspection. Those are the goals from my perspective, how to successfully manage an inspection. And we'll talk about some of the tools today for how to accomplish that.
Yeah, and from my perspective and the way I did it, and I'm not trying to put words in OSHA's mouth, but the way I did it was my goal as an OSHA inspector, as a file reviewer, as a negotiator for the final disposition of the case was I wanted the employees protected. The rest of the stuff came secondary after that. And so, the part you guys don't like is the deterrent effect that they use to ensure that it doesn't happen again, right? That's what the penalty's for, is we don't want to come see you again. And so all those things that Eric talked about, all those crescendo out to, make sure you're showing them in that light that you are safety and health minded as well. You want to keep your employees protected, and the rest of it will work out as we go. But they're going to come to do the inspection. They're going to knock on the door. You can imagine that's unannounced, right? Imagine if they said, hey, Tuesday at 9 o'clock, we're going to come see you, right? There wouldn't be a cricket there. Nobody would be there, and we knew that, right? They want to see the conditions that are normally there, so they're going to come unannounced, but they need to do it at reasonable times and regular working hours, and then all other reasonable limits and reasonable manner. So they're going to make sure that they're not trying to disrupt you any more than they have to, but again, they need to get a job done too. So this is to Eric's point, that communication needs to be there. We have this person loading a train, we need some time here, or we need to get our team together, we need you to sit in the lobby. That stuff shouldn't make them mad, right? As long as you're communicating. When it has the appearance that we're trying to go sweep the floor and do something different, then that's gonna raise their red flag there.
So my one remark about this is a provision of the Act that sort of defines OSHA's inspection authority, and OSHA has incredible power over employers during an OSHA inspection. This one expression is the little bit of power that employers do have in that process, is that OSHA must be reasonable in every way in this inspection. They have to come at reasonable times, their demands can't be unreasonable, their expectations can't be unreasonable, and this is the one thing that employers can sort of lean back on during the inspection and say, hey, listen, I know you want, training records for 100 people for the last 15 years, but it's gonna take a truck to pull up all those records and drop them off. Can we talk about, narrowing that scope of that request to a more reasonable scope? And they'll work with you in that regard. First of all, they don't know what your records look like. Usually they don't know, and they don't want all that paper either. So they're going to throw a request out there and hope that you talk to them about what is it, that they really need to evaluate this program. But this provision of the Act is the most powerful tool that employers have in this process, when otherwise it's OSHA that holds most of the cards in the process. So, and we'll talk about those cards right now.
Yeah, and don't be afraid too. The compliance officer may say, we want to involve the office. They got talented folks in the office that are providing direction, moving resources around. So if you have to get on a conference call talking about scope or talking about reasonableness or regular working hours or whatever it might be, don't be afraid of that. That'll be just a great conversation that you'll be able to have and be able to state your case with that. So as far as what OSHA can do, right? They have the right to inspect the workplace if they've got probable cause and they have hazards in plain view. They drive by, they see your guy hanging off the elevator. They have a complaint, things like that. So if they have probable cause or they have hazards in plain view, they've got the right to do the inspection. That comes by the act. They do not have to give you advance notice. So the people that tell you, hey, they never called, they just showed up, things like that, that's the way they do business. That's the way they've always done business. There's very few instances where they would have any kind of advance notice for going there. They have the right to inspect your records. Some of those are by regulation. Some of those will give time frames, and so you need to be sensitive to those of when you have to produce those. But they have the right to look at your records. If you have issues that you think that might be just specific to your facility or you don't want them shared, you can talk about trade secrets and the way you do it, and they'll have procedures to be able to do that. They'll have the right to be able to collect physical evidence, again, for you to take part in that, for you to take pictures, for you to take measurements, for you to take sampling alongside with them. That should not intimidate them, right? They're going to do the same thing whether you're there or you're not there, or whether you're taking those or not. So communicate again. What are you taking a picture of? When I did it, when I was in the field, that was my opportunity to teach. Why are you taking a measurement of that? Why are you looking at that plate? What are you looking for? That's where I'm teaching at that point and saying, this is the hazard I'm looking for. This is the information that can help you prevent that hazard or eliminate it, and that was what I was looking for. The last thing, they're going to have the right to be able to conduct interviews, both with employees and with management and everybody in between, however that workflow goes with you.
Just sort of to play the complementary side of what Tom just described, that conversation during the inspection, why are you taking this picture, why are you taking that measurement? You know, from the OSHA standpoint, you know, it's an opportunity for them to educate an employer about, well, there's a standard that requires it to be this height, or, you know, whatever the case may be. From the employer's perspective, remember that objective to identify problems early. One of my favorite things to do during a walk-around inspection is to say, hey, you know, my boss told me that I'm supposed to take a picture of everything you take a picture of. Why did you take a picture of that? Sometimes the compliance officer will tell you if they're in a teaching kind of mood. Sometimes they won't. But that's the way you identify a problem early. He says, well, look, I think you're supposed to have, guardrail's supposed to be this high, and I think there's a problem here. That would tell you, okay, there is a problem. I've got to fix this. Let's get working on this guardrail right away. Or, hey, this is not a working surfaces. Let me explain to you, compliance officer, how this space is used. It doesn't need to be guarded because, you know, we've otherwise got a work rule that prohibits employees from being in this space, and you might have cut off or nipped in the bud a potential citation. So the idea of having that dialogue during the inspection, critically important for successfully managing the inspection, and also, you know, there's an incentives on both sides of that process to communicate there, but that's one of the strategies I like to use, is to ask tons of questions, because you can identify those problems and maybe cut them off.
Yeah, and some of it's style points, you know, so you won't find it in the field operations manual. This is how you have to do that. And I'll tell you from when I was leading that team, what I told them is I didn't want the swoop and poop. Pardon me for that, but I didn't want you to just come in, can't do that, and leave, right? Because how are we going to get abatement out of that? How are you going to understand? How are you going to prevent the next one? If you have 23 facilities, how are you going to apply that to that next one, other than here, I got my citation and said I have to put a rail on here. So I love the teaching side of it. I think a lot of the folks within OSHA are going to like that just constant convey of information. Doesn't mean you're going to tell them certain secrets, or you're going to talk about the certain parts of the case file. You're going to explain the hazard, though, the abatement measures, because ultimately, like I said, what they want is a safe place to work. All right, so the employees' inspection rights, and again, rights and responsibilities for the employees. They have the right to be able to file a complaint. They have the right to be to file that complaint without being discriminated against or retaliatory action taken against them. That's an ugly situation. You get into that 11C kind of investigation, that's just an ugly one. You don't want any part of that. They have the right to be able to do that. You're not going to like it. You don't want that. And I can tell you from a consultant perspective or from an OSHA perspective, I want you to take care of it in-house. But if the employee feels that it can't be in-house, they have the right to be able to make that complaint. You cannot discriminate against them for that. Employees have the right to participate in an opening conference, or their representative to be able to do that. Also the walk-around, so they get to see what's going on. Right? It's not a hidden ball trick to them. They're out there in their work. OSHA's out there in your workplace doing that. The employees have the right to be able to have that information, again, through different representatives or union representatives. They have the right to a private interview. And again, this is not something trickery to you or anything else, but can you imagine you're going to sit down with your boss, the kid 3 days on the job, and he's going to sit down with his boss, and OSHA's going to start asking him questions? They want to make sure they get the right answer. They want to make sure they get the real answer, and there's no intimidation or even appearance of that, right? And I think we would all do that. I don't want to rat the boss out, or I don't want to tell him that in front of the boss that I hadn't been trained. It's not secret stuff that they're asking. What do you do? How long do you do it? How long you done it that way? Who told you about that? What programs have you seen? It's not really secret squirrel kind of stuff, but they want to make sure that they're getting the right information back. So they're going to do that in private interviews. Employees, again, can be involved in the closing conference, so the final meeting that's going to talk about hazards, abatement measures, the things that need to take place, they can be involved in that. They can be involved to some extent in informal settlement conferences and final settlement negotiations, and then also they have access to inspection records like monitoring records and things like that.
So it may not feel like it during the inspection, but employers have rights during the inspection also. The first one we talked about, straight out of the OSHA Act, you have a right that OSHA's inspection of you will be conducted as a reasonable inspection at reasonable times in a reasonable manner, et cetera, et cetera. So you've got a right to reasonableness. That's the most important right I think that you have. It's the one that you get to push back on if you feel like something is not being conducted in a reasonable way. You have a right to demand an inspection warrant, and we'll talk about when, if ever, that is the right thing to do. But the fact that you have the right is often a pretty useful tool, something that will allow you to negotiate maybe a narrower scope of the inspection with the threat of the warrant hanging out there. But generally speaking, we'll talk about it, it's not the best move, not the best strategy. You have a right to an opening conference, and this is also an incredibly important, incredibly significant right. Tom talked about they're going to show up unannounced, and the objective is to see the workplace in its sort of natural state. And every second that you are aware that OSHA is there, before they get out to the elevator and see the conditions in the natural state is probably changing, right? Hey, OSHA's here. That word gets to the back, and all of a sudden, a hard hat goes on. We start sweeping up the floor. We put away something that's not supposed to be out. It changes. But the reality is, OSHA wants to get from the front door to that observation as quickly as possible. There's, strategic reason for that to take as long as it could possibly take. And the fact is you have a right to that opening conference. Take advantage of that right. Ask all the questions you need to ask to understand, why is OSHA there? Are they there based on an employee complaint? If so, you've got a right to see the complaint. You should review that. It's going to help you understand, why it is that OSHA's there, what the intended scope of the inspection is. And if they show up on an employee complaint that says, hey, I think the horn is broken on the forklift and they just won't fix it, and OSHA comes in and says, all right, we're going to do a wall-to-wall inspection based on this complaint. You might ask some questions. Say, well, how are we getting from a complaint about a forklift to a wall-to-wall inspection? Sometimes there's legitimate reasons to do that. If there's an active emphasis program, OSHA can take an employee complaint and expand it, but you want to understand, is that what's happening, and why is it that we're doing this, expanded scope inspection? Ask all those questions. Make sure you've got the right personnel there and ready. If your company policy is that my safety director is the one who's going to be the escort during the walk-around inspection, it's reasonable to ask OSHA to wait for that person to be present to participate in the inspection, as long as the amount of time it would take for them to get there is a reasonable amount of time. But that opening conference, that's when all this stuff is hashed out. And that may, take longer than OSHA would like, but you've got a right to that process. You should exercise that right. You have a right to see a copy of a complaint, as we mentioned, to understand what is the basis of the inspection of OSHA's visit. You don't have a right to know who it is that made the complaint, and I would say you don't want to know, because if you don't know, it's really difficult to retaliate or discriminate against that person. And I can tell you that 9 times out of 10, the 11C, the whistleblower retaliation punishment that is bestowed on you for retaliating against the employee is going to be worse than the fines that come from the safety violation. So don't even ask, don't try to figure it out, you don't want to know. Just understand what is the complaint, what is the scope of the complaint, and now let's work with OSHA to make sure that the inspection is focused on just that topic, unless there is a legitimate basis to expand it. You've got a right to protect your trade secrets and confidential business information. That doesn't mean you can keep it from OSHA, but it means you can work with OSHA to make sure that they're not producing it to the public in response to a FOIA request. Maybe your competitors are interested in some special process you have. Maybe a plaintiff's attorney is trying to get access to information, the media, whoever it is. If you've got confidential, proprietary business information, tell OSHA about it, mark it on the document, and they should be working with you to protect that from public disclosure. You've got a right to accompany the compliance officer essentially at all times. Tom talked about the private non-supervisory employee interview. That's the one time that your designated inspection representative really should not be side by side attached to the hip to the compliance officer. Otherwise, that's the idea. They're not leading you, you're leading them, you're with them at all times. You know what they're looking at, you know what they're photographing, you know what they're sampling, you know when interviews are happening and all that sort of stuff. You've got a right to see all that happen, and you should exercise that right for sure. You do have a right to participate in supervisory level employee interviews. We'll talk about interviews separately as a whole section, but that right to the private interview is a right that belongs to non-supervisory employees. Supervisory employees, and we would have a dispute about this. I'm sure my friends from OSHA would not agree with the next statement I'm going to make. A supervisory employee does not have a right to a private OSHA interview. He cannot ask for the company's management representative to leave the room during that interview because the employer has a right to be present when evidence is taken from the employer. And a supervisory employee, their knowledge, their statements, their admission is imputed to the company. So if an admission of the company is being taken from OSHA, the company has a right to be present. And you might have a disgruntled, soon-to-be former manager who wants to get management out of the room to just, crush the employer in front of OSHA. They don't have that right. And that's going to cause a big fight with the OSHA representatives there because they believe they do have a right to privately interview anyone who requests that. But my understanding of the law, which I'm very confident in, is that if evidence is being taken from an employer, which would include management level statements, admissions, and knowledge, the employer has a right to be present for that. So that's an area of some tension that I'm not sure we have agreement about. Maybe we do, but that is a right that it's one of those that if that fight does start, you might want to contact counsel to talk through your rights in that situation. You've got a right to a closing conference to hear OSHA's findings, the recommendations they're likely to make in terms of citations and things like that. And you've got a right to challenge citations. That last one's really important. A lot of people think, hey, this is the federal government, they're the authority here, what they say goes. Well, that's not the case. You've got a right to challenge those citations. And OSHA gets it wrong a fair amount of the time, and I'm not to badmouth them. It's a very difficult job because they're trying to discover things that you're trying to hide from them, and they've got the shortest statute of limitations of any enforcement agency out there. They've got a small window of time to find, write up, and issue citations, and as a result of all of that environment, mistakes get made. And so just because a citation is issued doesn't mean get your checkbook out. You've got an opportunity to evaluate that, identify whether there's defenses to that citation, and even if they do have it right, there's opportunities to negotiate with the agency a different outcome to those citations, and we'll talk about some of that today as well. So before OSHA walks in the door, there are things that you should do to be better prepared for that inspection. Yes?
Yeah, I'm sorry. Just to back up on that.
So, all right, so that's a great question. Let's tackle the first one first. My view is there is without a doubt, no question, the employer has a right to be present if a supervisory level employee is being interviewed. And I'm carefully using the word supervisor instead of manager. For whatever reason, OSHA sort of draws the line differently than most other agencies in the Department of Labor. Some talk about management versus non-management, exempt versus non-exempt employees. From the OSHA standpoint, OSHA will attribute knowledge, admissions, and statements of a supervisory employee to the employer. And supervisory just means you supervise the work activities of someone else. That could be a non-management employee that has no hiring and firing authority, no disciplinary authority, but if they are supervising the work activity of another worker or other workers, they are supervisory. And if they say, yeah, I knew that the guardrail was supposed to be this high, and I knew that it wasn't that high. In fact, I took the bar down because it was easier to do the job. You've got a supervisor who's just made an admission that establishes a violation, maybe even establishes a willful violation. If a person in that capacity who can bind the company in that way is giving testimony to OSHA, the employer has a right to be present, even if that individual doesn't want you in the room. And that might spark a fight with the compliance officer, but I'm confident in that right. The other side of that, the non-supervisory employee, I would say it's a pretty similar analysis, and 100% sure that OSHA would disagree and have a fight with me about that. But a non-supervisory employee can say, I would like to have Mr. Conn in the room with me for this interview. I tend to discourage that, because I want that private interview to happen. I don't want to have that fight with OSHA if it's not necessary, but there are some times where the employee, for whatever reason, really wants it. And in some circumstances, like if it's a fatality inspection, it might be worth having that fight with OSHA. But the way that plays out is OSHA has subpoena authority. Generally, they start with a voluntary request. Hey, come sit down with me for an interview. I'd like to have this private interview. The employee, if he really, really wants it, and you cannot intimidate him, coerce him, I really don't even suggest to them that they can ask for a management representative to be present or a company's attorney to be present or anything like that. But if they demand and they ask for it, they're going to tell that to the compliance officer. The compliance officer is likely not to proceed. He's going to say, well, I'm going to go get a subpoena then, and we're going to do this as a more formal, maybe deposition type experience for you. And the reality is, at that stage, a subpoena is issued. That person who is subpoenaed for an agency interview under the Administrative Procedure Act has a right to have a representative of their choosing present for that interview. So my analysis of the law is that a non-supervisory employee who's subpoenaed for an interview, which is likely how that's going to go, has a right to say, I want the company's attorney to be present. There's a potential conflict of interest there. Both parties would have to waive that conflict of interest, but you could proceed in that regard. It's a less clear question of whether that employee's manager could be present for that formal interview, but I know the answer for counsel. It creates a different, it's like the warrant issue that we're going to talk about. If you do that, all of a sudden OSHA is very unhappy. They're likely to handle the inspection a little bit differently. They're likely to handle the interview a little bit differently, differently to your disadvantage. They're going to turn over every stone. They're going to have be particularly careful and thorough in their inspection. But sometimes, it may be worth that fight. Like I said, in a fatality inspection, for example. But there is a different way that those are handled. I'd be very interested to hear Tom's perspective as a former OSHA person on both those questions, whether that does create the fight, how the COSHA is likely to handle it. But that is I get that question in every one of these presentations. So
in general, I'll agree with Eric on the management interviews. I mean, I think that was something that we always we didn't like, but that was the way it went down. As far as the employee interview, I think Eric's exactly right. We would have taken exception to that, and we would have looked to have that interview performed outside of work or in a subpoena type thing. And again, that was just to make sure we got the right information, right? That Big Brother wasn't sitting there kicking you under the table going, no, that's not what they were looking for. And so we'd taken up the fight a few times and not trying to soft shoe around the issue, but I think each of them are different. I think where you get into the really sticky situations, the lead man versus manager versus supervisor, and some of these kind of situations like that, and that's where we relied on counsel from the solicitor's office, and they would be the ones that would help direct us on which way to go. But ultimately, I know the compliance officers, they're going to want employee and them in the room, that's it. Maybe union rep that would be there, but not usually a management representative.
Yeah. So the question was, if you didn't hear it, does the non-supervisory employee have a right to refuse to participate in an interview with an OSHA compliance officer? And the answer is that anybody has a right to refuse a request for a voluntary interview because it's a voluntary request. And OSHA has subpoena authority, and they can compel anyone from the CEO to the most junior guy at the company, non-supervisory, by way of a subpoena that's enforceable in federal district court. And so you tend to see if a manager refuses for a voluntary interview, I would say 9 times out of 10, OSHA's going to get a subpoena. Getting the subpoena is nothing. They've got them in the desk drawer in the area office. They write them. Enforcing them a little bit different, but not that much more difficult. So they're almost certainly going to issue a subpoena for a management interview. For a non-supervisory employee interview that refuses, I would say if the person is just a sort of representative, grain loader, and there's 5 others, they'll say, okay, we'll just go interview somebody else who's willing to talk with us. If it is a witness to an incident and it's vital information that the agency needs to gather from that particular witness, even if they're non-supervisory, they're likely to issue the subpoena, and you cannot refuse. I mean, you can refuse the subpoena, then you'd be held in contempt of the district court, and there's punishment for that. You could even end up, a civil contempt. You maybe pay a fine for that. But the idea would be you don't want to get crossways with a federal district judge, so you may have to participate in that. Develop citation items to write up in a citation package. And then there's another reference here. Go on our website. I'm happy to email it to you if you send me an email. We have an OSHA inspection toolkit, which is sort of the lawyer's perspective on OSHA's field operations manual. So you'll see those slight differences like we talked about in the interview process. To the extent, what is the full extent of that right to a private interview? You'll get the different perspective from my standpoint. But I think those are good tools to have looked at before OSHA knocks on the door. The other thing that I think is really, really important to look at in advance is OSHA's enforcement emphasis programs. If you go on OSHA's website, osha.gov, under the enforcement page, there is a list of all of the active enforcement programs broken down by region, if it's a regional program, or a list of all the national programs. Look at them, and the first couple of pages, it will tell you, who does this apply to? And you'll see, is my industry covered by this inspection program? And if it is, read the directive, because the directive it's not technically for us, it's for the inspector, but it tells the inspector how to conduct an inspection under that emphasis program. So if you go and read the grain handling regional emphasis program or local emphasis program that applies to your facility, a lot of times it will say, here's the documents. Hey, compliance officer, here's the documents you need to ask for. Okay, well now I'm going to go over to my safety manager and say, do we have all these documents? Do they appear to be compliant? If it's a list of, training topics that you're supposed to see in those training records, do we have everybody trained on these topics? If it's a housekeeping check sheet that shows that we're keeping up with our housekeeping, what do our check sheets look like? This is no mystery, it's no surprise. If you go and look at the directive, you'll know exactly what OSHA is going to ask for, and then you go do your own audit and say, do we have all these things? Are we ready for the inspection? It will tell you the sort of questions that the compliance officer will ask during an interview. So go interview some of your employees. Say if you were asked a question about what our housekeeping policy is, how would you answer that? And if you're not getting the right answers, you need to do some more training and get people current. So, it's not this great mystery what's going to happen when OSHA shows up. They forecast it right there for you. They've written it in the directive. So I'd encourage you to go back, pull the directives that apply to you, read them, and then you will know exactly what's going to happen when OSHA shows up to inspect your facility. And then the last thing I would say from a pre-inspection standpoint is think about who do you want to participate in this process? Who are going to be the people at my workplace that are going to escort the compliance officer during the inspection? Who's going to round up all the documents to produce to the compliance officer? Who's going to coordinate all the interviews? If OSHA is going to be taking photographs, and they almost certainly will be, who's going to take those side-by-side photographs? Don't try to come up with that on a whim when OSHA knocks on the door. Think about that today. All right, you're going to be our primary interface with OSHA when OSHA gets here. So I want you to be the one that goes and reads the field operations manual and reads Conn Carey's inspection toolkit so that you know how to manage the process. And I want you to have the tools that you need, like a camera or the technology to do sampling if sampling is going to be done by OSHA, things like that. Think about that in advance. Who's going to play those roles? Educate those folks that are in those roles so that they're prepared when the inspection begins.
Hey, before you go too far that way, too, just from experience, this guy might have a dentist appointment, he might win the lottery, he might have a vacation day. So you got to have a little bit of redundancy in your system, right? Not just one person, because if that person's out, then you're all looking around going, now where do I start? So it's important to have a backup to that. And I would tell you the same thing with the injury and illness recording system. You don't want to fall down on that opportunity because, like I said, I won the lottery and I'm not coming back for about ever, or I'm on vacation or my kid's sick or whatever the situation may be. You want to make sure you're hitting your legal requirements. So I would have some redundancy built into that. And we get asked this a lot, or I do. Well, what if my guy's not there and I want this manager to go to this other facility and represent for us there? That's fine. Communicate that with OSHA. Don't make it look like the stall tactic. Typically, they'll wait an hour. You know, you get to cool them in the waiting room for an hour. After that, they start getting a little itchy, right? Their ADD goes, and they're looking to, where do I go? And so they're probably going to make a call back to the office and say, boss, how do you want me to proceed? So you need to let them know, hey, I'm an hour and 15 out. Is that going to be okay? Do you need to call the office? Whatever it's going to do. If not, they're going to leave and go get a warrant.
Yeah, so I mean that's had a conversation with our friends from OSHA about that very circumstance during the break. That is the one time in my career that I've actually sort of advised a client to ask for a warrant, and I almost never do this. But we have, you know, a couple of my clients where the company policy is this is the person who will accompany OSHA on any inspection at any one of our facilities. You know, probably the corporate safety director, right? And that person is not always at the elevator by happenstance where OSHA shows up. And so our policy is to ask OSHA to wait for that person to be present for the inspection. And, you know, as Tom says, they'll wait a reasonable amount of time. If you read the field operations manual, it says an hour or 2 hours. I think you can't define reasonableness by a specific amount of time. Reasonable is reasonable. And if your intent of asking them to wait is not nefarious, it's not so that I can go do, you know, 3 months worth of housekeeping in 3 hours. If it's a legitimate policy that this is the person who is our designated inspection representative and he can be there in 4 hours, then my perspective, 4 hours is reasonable. And at the end of the day, you have that discussion with OSHA, you ask them to wait. I try to get creative and say, all right, let's do the opening conference. So my guy will call in, we'll do the opening conference by phone. And if you want to start looking at some documents, we'll pull some records for you. But what we can't do is have the walk around begin until this person is present. So let's do as much as we can without that. 9 times out of 10, the agency says, no problem, let's make that work. 1 time out of 10, I had the agency say, no, I refuse to wait, I want to start right now. I said, well, all right, well, we've got a right to demand an inspection warrant. I'm going to ask for a warrant, and if I ask for a warrant, not only are you not going to be able to start right now, you're not going to be able to start in 4 hours when my guy is here. You're probably not going to be able to start tomorrow. It's probably going to be 3 or 4 days before you get back here with a warrant. How is that better than the solution we're trying to work out here? And 1 time out of 10, they just refused and said, all right, fine, go get a warrant. They got a warrant, came back a few days later. The place was in the best shape that it had ever been in. And, you know, we had done some refresher training. Everything was great. And, you know, the inspection, I'll tell you, you know, OSHA will insist that they do not take any retaliatory action against someone who demands a warrant. And there's policies against that and there's laws against that. But in my experience, there is just a little bit of a difference in the attitude and a little bit of difference in maybe how thorough that inspection is conducted when you've demanded a warrant. And they will say that it has nothing to do with you exercising your right, but the reality is, you know, it pisses them off. So my experience, don't do it, but unless you have to. But the fact that you have the right to demand it is useful, right? I mean, every one of these circumstances where I said, I need you to wait more than 2 hours, if I couldn't have said, and if you don't agree to wait more than 2 hours, I'm going to make you get a warrant, they would have said, no, I won't wait that long. But the fact that you can demand a warrant gives you a little bit of leverage right there in that negotiation. So you have the right, and, you know, you can do that.
Teddy Roosevelt said it's better to be pissed off than pissed on. So as the representatives of the agency, they shouldn't do it with passion or prejudice, right? And the way I think what they're going to try and do is make sure their house is in order, that they have the legitimate reason to be there. Within the confines of the OSHA Act, they have a legitimate reason to be at your facility. So if you ask them to go get a warrant, it just means they're going to travel back halfway across the state. They're going to go to the magistrate's office. They've got a stuffed bald eagle there with a Department of Interior evidence tag on it. It's a cool place to be, no big deal, and the judge writes the thing. But to Eric's point, now you're under the order of a judge. The judge said, you're going to go find this out for me, OSHA. You're going to do this task. So he's probably right. You probably get a little bit finer detail at certain times because you're satisfying a federal magistrate's order that you're now executing in a sense for them. And so I don't think it's ever made me mad. I tried to talk smack, right? And very few times I had to get a warrant. I tried to work those issues like, Eric, hey, let me start with this or start with that. There's times where it had to be, and I know I had a bridge contractor at one time. He had like 2 hours worth of work. left, and he knew I was 4 hours from home, so you get out of here, go get a warrant. I come back the next day, the birds are chirping, nobody's there, and it's done. But I tell you what, it was a lead inspection. There was lead-based paint chips all over the ground. You know, we still made a case. I didn't have to be there to do it that way. They're good at what they do, so they're going to try and find another way to do it. So if you're cooling them to buy time, make sure that you're doing it for the right reasons. And again, if they're able to work with you and start looking at some of the things, then that might be a way to do it. And don't be afraid to say, hey, can we call the office and talk about how we can work through this issue, because my guy's 3 hours out.
So I threw the slide about warrants up on the screen while we're talking about it, because we're basically covering this issue right now. The origin of the warrant right is the Constitution. You have a right in your workplace, essentially the same as the right you have in your home, to be free of unreasonable searches and seizures. And an inspection by a governing authority of our federal government must be, reasonable. They have to have probable cause. The difference here, and there's a significant difference in that private right in your home or your car or on your person, it's sort of that personal probable cause is a whole lot different than regulatory probable cause. And so the reality is, I think I can only think of one circumstance where a judge ever denied OSHA an inspection warrant or even limited the scope of the warrant that OSHA was asking for. So they're going to get it. This is not a tool that you can think, hey, maybe I won't be inspected if I demand the warrant. It's almost certain that the judge is going to defer to the agency. It does make the agency think a little bit more clearly about the scope of my inspection. What is my real authority? What do I actually have probable cause to evaluate at this workplace? But generally speaking, they're going to get the warrant that they ask for. So you've got to think about what is the purpose of doing this. And the tip that I've already talked about is, you don't want to create a negative, you don't want to start the inspection off on the wrong foot if you can avoid it. So generally speaking, I don't recommend it, but there are some times where it does make some sense to do that. But again, in my 19 years of doing this, it's only happened once, and it worked out generally fine. It was only about making sure that my guy could be present for the inspection, and it ended up happening 4 days later with my guy present. The inspection seemed to be a little bit more careful and more thorough than usual, but we did just fine. Going back then to the stages, and now the inspection begins.
Yeah,
an hour
here we
and
go.
20 minutes in.
It's all yeah. Here we go. So it's all going to start with an opening conference, right? This is the introduction time. This is the time where they're going to let you know purpose, nature, and scope of what they're going to want to do. So the purpose, why they're there, the nature of the visit, and then what they think they're going to need to look at. Of that, they're going to have document production. They're going to ask you for safety and health programs, training records that are appropriate, things within that same scope that they've identified. Then they're going to want to go out and do a walk-around portion. That's what we call the inspection gathering, right? So they're going to take their measurements, they're going to talk to employees in the interviews there, but that's where they're going to gather their evidence. That can take minutes, hours, days, months. That can take a long time to get through that walk-around portion, depending on the situation. Multiple, big explosion, things like that. That might be a lot in the evidence collection portion. When they get done, and again, I think their intent and ours would be, this is where the compliance safety and health officer talks to you about hazards. Their job is to identify hazards and identify facts at the facility, and so they're going to talk to you about what they found. They're going to probably, I hope, they give you encouragement on things that you were doing well. That's not in the field operations manual. That's just sometimes what they'll do. But in that closing conference, they're going to talk to you about, hey, I saw this guardrail missing, and what's it going to take for you to put that back up? How long will it take? Because that's what they're going to take back to their management representatives and say, hey, boss, this is what I found. They're going to try and meet their legal elements. If they do, they're going to put it in a case file that's going to be reviewed at the area office, and the area director is going to have that authority to issue a citation or not. So sometimes we'll talk in the closing conference more about what that looks like. And then if it's warranted, inspection or the citations will be issued and sent to you. Registered, return receipt, registered mail, so green card. Opening conference. Guy shows up with a hard hat, it's got a piece of duct tape on it, says OSHA, and he says, I'm with OSHA, I'm here to help. I would question that. not the I'm here to help portion, but it's going to be very, very detailed, right? They should come up, they should have a credential, right? They will show that to you. It'll have their picture on it. It'll identify the agency they're with. It'll even have a number. If you're doubting Thomas like me and you think this guy's not telling you the truth, you can call the office and say, hey, there's a guy here. His name's Conn. He's got a credential number 26493B. Is this really him? And they're going to be able to verify that for you. They're not going to let you take a picture of it. They're not going to let you take a copy of it because they don't want you recreating that. But they should be able to tell you who they are, why they're there, what they want to look at, and what that encompasses. Again, to Eric's point earlier, that scope should be either, hey, we got to look at everything, and this is why we need to look at everything. A complaint or a referral. A complaint, they should have a piece of paper they show you. It's going to say alleged safety and health hazard. You know, employees are exposed to health hazards, bathroom stall number 4 doesn't have a door on it, whatever it is, they're going to have a complaint form that they should be able to show you. You should be able to have a copy of that, right? That's the scope of what they want to look at. NEP, LEP, that would be grain handling, powered industrial truck. They'll tell you what those are. Or an accident, hey, we got a media referral, or hey, we heard about this accident, maybe you called it in, and they're going to look at that. Again, that scope should be relative to what they need to look at. That's the portion where you may ask them, you know, where are we going to go with this? How big does this need to get? And that's a portion where you have to be at least a little bit defensive and say, you know, we got to keep this within the scope. It's not their opportunity to go open up all the closets, right? They should be within that scope. Now, that scope can change. The way I used to say it is if you can see it, smell it, taste it, or hear it, you can expand that, right? So the guy comes through with the fork truck doing donuts out in the gravel driveway, and I'm there looking at a truck platform. Guess what? We're going to start talking about forklift operation, the powered industrial truck thing, because again, there was a hazard in plain view. They can expand that scope. They should request documentation. Normal stuff is injury and illness log data for a number of years before, and written programs, training programs are going to be relative to that scope. So that stuff I would be prepared for. And again, I would give them what they ask for. This is not your time to give them more than what you need. And then resolve the warrant issues. Again, if there's the scope doesn't make sense, if something doesn't smell right, you're going to exercise your right on the warrant. Then you're going to push through that at the opening conference.
So my view on what an opening conference is all about is, to me, it is the most critical part of the inspection. It is the last chance to maybe not be inspected. Right? I've had instances where OSHA showed up and said, hey, we're here under one of the emphasis programs to conduct an inspection under the emphasis program. We say, all right, hold on, let us take a quick look at the directive. Look through the directive and see it says, oh, if you've been inspected, if you've had a comprehensive inspection in the last 3 years, you're not supposed to be on the list anymore. And we call up and say, hey, look, we just looked in your OIS system, OSHA, and it looks like we were inspected 2.5 years ago. So, you know, we want to cooperate with you, but it doesn't look like the directive applies to us. And they say, oh, gosh, you're right, we're going to walk away. Or it says, the directive says this applies to companies in this NAICS code. And we say, this is not our NAICS code. Our NAICS code is slightly different, so we're not covered by this inspection. Lo and behold, that's right. You talk about it with the area office, more likely the COSHA is going to get somebody else on the phone. But if you've got a reason to say, hey, you're not supposed to be here at all, you know, this is the last chance to do that. Because once you consent to the inspection, it doesn't matter whether they should have been there in the first place. If you've consented, they walk in the door, they do the inspection, that's it. You can't later say, this citation's no good because I wasn't supposed to be inspected under this program. So you got to do that during the opening conference. The opening conference is the last chance to say, wait a second, you're telling me you want to do a wall-to-wall inspection, but it strikes me that you're here because of an employee doing donuts in the parking lot in his powered industrial truck. How about we just limit this to powered industrial truck operations? It's your last chance to have that negotiation to try and scale down the inspection. So critically important. It's also critically important for the reason we talked about earlier, that every second that you're sitting down in that opening conference is time that things maybe are changing in the back of the house. And that's, you know, the OSHA can cite you for something that existed, you know, they don't have to see it and take a picture of it to cite you for it, but it's harder to cite you for that if they don't see it. So things do change during the time of that opening conference, and so that's an important time. You want to introduce your inspection team to OSHA during the inspection. So, for example, you know the inspector is going to be asking for documents. He's going to be asking to conduct interviews. You can say, hey, John here is our custodian of all important records. He's our safety manager. He's going to be able to get all the records that you're looking for during this inspection. I just ask you to make your request to John during the process. So you've circumvented the situation where the compliance officer is making requests to 5 different people, things fall through the cracks. If you introduce the person, say, this is the guy that you need to go to for records, that simplifies the process, makes it go smoother during the inspection. This is the guy that's going to escort you whenever you need to go out into the elevator, whenever you need to go see something out on the shop floor or whatever. Then that will simplify the process. There shouldn't be fights. There shouldn't be surprises. When the compliance officer says, I'm ready to go out to the elevator, he knows that he's got to hook up with our escort for that process. So introduce the team. Explain your document protocol. One of the things that I think is really important in the process is to ask OSHA to put their document requests in writing. I usually say, hey, look, nothing formal. You certainly don't need a subpoena. You don't even need to type anything up. Just write it on the back of a paper towel. It's just easier for us to keep track of what you're looking for if it's in writing. And I've never gotten any pushback from OSHA making that request. They're happy to do it. It's easier for them to track what they've asked for and what's been produced as well. But it's really important to make that process go smoothly, is to get those requests in writing, and I establish that right up front in the opening conference. Establishing an interview protocol. That's a little bit trickier. What I try to do with OSHA is to say, look, I'm sure you're going to want to conduct interviews during this inspection. All I ask is that you tell us who it is you want to meet with and when, and we'll organize that, get it scheduled, we'll get them brought up here, sit down in the conference room, and do that interview. Sometimes they'll go along with that. Other times what they'll want to do is to get out onto the floor and just sort of interview people in this kind of stop and talk sort of setting. Here's a grain handler, digging up a spill in the boot pit. I want to interview them about this process or about housekeeping or about whatever, and they just sort of do it during the walk around. What I try to do is avoid that and make everything be planned, structured, organized, so that we've got an opportunity to visit with employees before the interview, prepare them, and to avoid some of that business disruption we talked about earlier this morning. And if it looks like it's going to be a longer term inspection, there's been a serious accident, OSHA is likely to come back multiple times as part of the inspection, I try to arrange for a daily closeout meeting. Just let's get together at the end of the day with the compliance officer, take their temperature a little bit, identify some of those problems early in the process, ask if they've seen anything or found anything they're concerned about, ask if they're getting the documents and information that they need. Is there something they believe is outstanding that we think we've replied to everything and they're getting unhappy that they haven't seen some record yet? It's an opportunity to sit and talk about that. And more importantly, it's to ask, so are you coming back tomorrow? What are your plans? Do you need to see anything else out in the facility? Are there any interviews that you think you need to conduct tomorrow? Are you going to do any sampling? What is it that you have planned to do tomorrow? Gives you an opportunity to plan for that as well. If it's sampling, then you can line up, maybe you need to get an industrial hygienist on site. Maybe you need to get the tools to do side-by-side sampling, so you can plan that activity. If it's an interview, it might be an opportunity to prepare that witness for the interview. If it's more site visits, an opportunity to go do your own little audit of the areas where that site visit might go. Now, OSHA, often will keep their cards close to the vest and they won't tell you what their plans are, but if it's a multi-day, multi-week, multi-month inspection, there is a little bit of an effort to coordinate because those can be very onerous. They can, first of all, it helps them get access to information on a more expedited basis if they tell you what they're trying to accomplish. So sometimes they'll share with you, sometimes they won't. And then the last thing, this doesn't come up often, but if you do have highly sensitive processes, trade secret processes or things like that on site, you can ask OSHA for the opportunity to review their photographs to make sure that there's nothing that they captured in a photograph that would depict the company's trade secret information. And if so, you can ask them to protect that in a special way in the file. But it's also an opportunity, again, to see what are they taking pictures of and why.
So the opening conference, the last thing there, that's where the first 2 lies of the inspection are told. Oh, go ahead. Documentation, is there a limitation on how far back they can request? I don't know there's any limitation on it. Some regulations are going to limit how long you have to keep things, say 300 logs and things like that. So for me to ask you for your 2001 data, you're going to say, hey man, I don't have that, and that's going to be the way it's going to be. But I don't, they can, again, that's part of that that reasonableness is to define what that scope is. And, hey, we've made a lot of changes since '89 and now, so our HAZCOM training from '89 to, this year is not appropriate. So again, I think that's a little bit organic. There's not really anything in the Field Operations Manual directives or act that will limit what that is. I think you'll have to work through that based on the appropriateness of that.
Yep, exactly right.
Yeah. Anything else? All right. So first two lies are told during the inspection at the opening conference. They knock on the door, you say, hey, we're glad to see you. And they say, hey, we're here to help. Come on, that's an old OSHA joke. You are glad to see them, and they are there to help. So that's just the way it goes. Hey, we wanted to do document production, and again, they're going to ask for this. And I'll tell you my style and what I asked out of my folks, and I think is pretty much the way throughout there. They're going to talk about these with you. They're going to give you this verbally. Say, hey, we need 300 logs for the last 5 complete years, and year to date, I need number of hours worked. I want to see 300 a day. Whatever it is, they're going to go through that, and they're going to ask you for those things. Certain regulations, like the record-keeping forms, they're going to tell you have to produce those in a certain amount of time, right? You want to make sure you hit those. I think record keeping is 4 hours, and you got to do those. Don't fall on your sword on something like that. If you've got them, make sure they get them and they can look at them within the 4 hours. On the document production, though, you're gonna talk about what those look like. Again, from the OSHA perspective, they should tell you about what those are verbally. And then what I always did, because I wanted to make sure I got that information and I wanted to make sure I was setting up for my next phase. If I didn't get the information, I'd send you something on letterhead, fax, email, snail mail, whichever venue. But here came your list of the things I asked for. And again, you could be like a checklist and check off hazard communication program, bin entry program, powered industrial truck, all the things that were asked for. So you have to weigh, though, again, you got to keep it within the scope. If you think it's outside of the scope, then you might have a little resistance to that. But their response to that is going to be, we're asking this from you voluntarily. If you dispute that enough to where you say, hey, I just think you're out of bounds and I'm not willing to do that, they can pursue a subpoena through their solicitor's office. They're going to pursue a subpoena that's going to say, hey, you're going to produce these documents, this place and time that you're going to produce those. And again, you don't want to, you do not, if you get a subpoena, that's not a choice that you'll have there. I mean, if you think it still doesn't smell right, you're going to need to let counsel know, but I would not miss that opportunity. It's not your opportunity to create documents, and Eric said early, don't shred stuff. This is, you got to answer the questions as they're asked. You're going to produce the things that are there. But again, this is not your time to get creative and start making documents, make yourself look better, nor do I want the shredder going and make it go that way. The inappropriateness or the things that do not look above board are very hard to keep in a circular fashion, and usually will come out, and that comes out very negatively with the agency. If you don't want them to see it, don't leave it out, right? So don't line your library or your meeting room with all these programs that they're not sure if you have. And again, I believe in what they do, but they're gonna have to ask you to do that, right? So they're gonna ask you for information, and that's where you'd want to present that. Don't volunteer information. This is not your time to sing the second verse of How Great Thou Art. You're going to be Ollie North. You're going to answer the questions that they ask you. They're good at what they do. They know how to do this, but you're going to respond to what they give you, right, for information. And then make sure that you're reviewing the stuff, make sure it's responsive, that it's accurate to what they're asking for, that if there's any privileged or proprietary information, that you're working through those with them, because they'll be able to control that in the file so it does not get out and your competitors or anybody else wouldn't see that under the Freedom of Information Act.
On the flip side of that, don't create new documents to sort of start to advocate against a citation. The flip side of that is there's no obligation to create a document just to be able to respond to an OSHA request. One of the trends I've seen in inspections over the last few years is that OSHA is, submitting to you what theoretically is a document request, but really it's an interrogatory. An interrogatory is not a request for a record, it's a request for a narrative response from the employer to explain something. And the reality is that that's not something that OSHA has a legal right to demand during an inspection. They can't issue a subpoena that compels you to write a narrative to explain how a process works. So if they ask for an operating procedure and you don't have one, first you want to figure out, hey, am I legally required to have one? This would be bad news if I don't. But if I'm not legally required to have one and one doesn't exist, I don't need to sit down and write one to be able to respond to that request. The answer may be, we don't have a written procedure for that task. In an interview, certainly you can ask an employee to describe it, but there's not a writing that exists that presents that. Another example of that might be, hey, we'd like a list of all the employees who performed this task in the last month. Well, I mean, if there's not a, if that's not on some schedule somewhere that already exists, you don't have any duty to create that list. OSHA has a subpoena authority to compel you to produce documents that exist. They don't have authority to make you create documents. So it is, as Tom said, it's not the time to start to create things for an advocacy purpose. You want to sort of figure out where the inspection is going, and there may be a time to do that. It's also not a time that you're required to do anything like that in response to an OSHA request. So something that might be masked as a document request, but it's really asking for, a narrative response, you don't have a duty to create that. Might be a strategic reason to do it, might not be, but that's something you've got to evaluate on a case-by-case basis.
And again, be ready for them to ask you, well, do you know who these people are? And you list them off, and well, why didn't you respond to our request for the list of that? And you're just going to be honest with them. We don't have a list. It's all right here. So then you're going to be able to respond that way. So this is also best practice. Keep a log of it, right? Basically, the information that they have, you want to keep a copy of that too. If it escalates and you're going to need to refer to that, you don't want to guess, hey, did we give them lockout procedures? Did we give them our periodic review of that? It's going to be, you're going to have a detailed log, making sure that you know what you've produced to them and you know who's got that. And then, again, if there's any trade secrets or anything else that you expressed with them.
And don't give them originals either. I've run into that a couple of times where somebody hands over all their training records and says, when do we get those back? So, well, I mean, technically you don't get them back. You can ask for them. You can make a FOIA request. You can do it in discovery in a contest. But keep your originals. Don't give your originals to OSHA.
They might want to see the original, but they don't want the original either. They don't want to have to keep it.
So I have a quick question on the record keeping, right? So we've had a lot of discussion here about the electronic submission of the record keeping. We had the change in practice in the previous administration. It traditionally was 3 years that you had it, and then it went to 5 years. Then we had the litigation, right, about 6 months. So where is it at? Has there been any change? I mean, what is your suggestion on that issue?
Well, so the rule hasn't changed in terms of how long you're required to maintain a copy of the log. In practice, you would see that the first inspection request used to be your last 3 years of record-keeping data. Sometimes they'd ask for more depending on what the purpose of the inspection was, but it was sort of in practice, it was 3 years. Now I'd say it's a mixed bag. I still see some requests for 3, some requests for 5, but nothing has changed from a regulatory requirement that you maintain them for 5 years. The 6 months issue, really fascinating issue if you're a giant OSHA nerd like I am, is that OSHA for decades treated the statute of limitations for injury and illness record-keeping violations to be 5 years because you were required to keep a copy of the log for 5 years. So if you had something on the log 4 years old that was recorded wrong, or you didn't record it and you should have 4 years ago, they could cite you for it because you were supposed to keep that piece of paper for 5 years. Going through the courts in a case that I was involved in, the D.C. Circuit, ultimately said Judge Merrick Garland, interestingly, said, hey, there's a strict 6-month statute of limitations for record-keeping violations. There is a occurrence of a violation when the thing was supposed to be recorded, and you either got it right or you didn't get it right. You either put it on the log or you didn't put it on the log on that day. And OSHA has 6 months from that day to issue a citation for that entry on your log. And it has had a sort of an astonishing impact on OSHA's ability to enforce the record-keeping rule. I think it was something like 85% reduction in record-keeping violations from the time of that D.C. Circuit decision to basically today. OSHA it went through a rulemaking process and actually finalized a rule to redefine that statute of limitations, to basically say it's a continuing violation and we can cite you for 5 years. In the opening months of the Trump administration, we did talk about how little things have changed. One thing that did change was that rule was basically repealed by this tool called the Congressional Review Act. So OSHA wrote a rule to sort of give themselves the better ability to enforce the record-keeping standard, and that rule was killed by the Trump administration and the Republicans in Congress. So not only is the rule 6-month statute of limitations strict for record-keeping violations right now, because it was repealed by the Congressional Review Act, OSHA can never promulgate a rule in the future that tries to expand that statute of limitations. If that's ever going to change, now it has to happen by Congress. So it's an interesting situation. So one of the things, I used to always say, hey, you've got, I think it's 3 or 4 business hours to produce, whatever it is. This is really one of the only documents that there's a deadline to produce to OSHA when they request it. And I used to always dive in there as quick as I could and do a record-keeping audit. Say, do the records look good? We were auditing 5 years worth of records to try and make sure everything looked good before they were produced. Well, now I don't really care what the records look like from a year ago or 2 years ago or 3 years ago. There's important information on there, right? OSHA can look at it and say, hey, you should have known you've got a problem with this machine because you've had 4 people injured on this machine in the last 5 years. So there's valuable information to learn from that, but you're not going to be cited for a record-keeping violation from anywhere more than 6 months, 6 months and a week from the time that the citation is issued. So it's an interesting situation now on record keeping that right now it's hard for OSHA to enforce that standard. They've done some smart things to be able to do that. For example, the electronic record keeping rule does put your injury data in OSHA's hands more proactively, but otherwise it's a hard standard to enforce now. Walk-arounds.
All right, walk-around inspection. So this is where the rubber hits the road. This is where they're gathering the information. So again, that scope you've defined in the opening conference. You guys have kind of agreed to it. If you've had to mitigate that or reduce that or talk about those kind of things or fight about it, whatever you want to say, you've done that. Now we're going to go out there and take a look at it. Never ever would I let the compliance officer go there by themselves. Right? You don't give them the keys and give them a golf cart and say, go find what you find. Right? And I can tell you in my career, only one time did that happen for me, 12 years in the field, and I hated it. I didn't have anybody to talk to. When I'm seeing stuff, I'm taking pictures and then I'm going back and the guy was just mad and didn't want to go. But I would never let them do that. I would never let somebody just go by themselves there. Find a representative, somebody that can go and make sure they're doing the right thing. You want them to take notes. You want them to take pictures. You want them to take measurements. You want them to be inquisitive, again, be respectful. And I would be asking everything along the way. Why'd you take a picture of that? Why are you looking at that? Why is that important to you? Again, that's a training time for them. Some may tell you more than others, but in my way, it was just I was jabbering the whole time. Employee representatives may go along with them. And again, union representatives, there's been a little wider scope on that. But again, that's to let the employee groups know this is what they're looking at, this is what they're finding, and this is the way they're heading. So we talked about side-by-side images. And I just, I manage that up front. If you take pictures, this guy's going to want me to take pictures too. So tell me what you're taking a picture of, and we'll do it that way. They're usually not going to share their pictures with you, so you can't say we're going to be efficient and just hand me your card at the end of the inspection. I'll put it into my computer, and I'll have the same thing. You're going to have to take your own, but you want to do that side by side. Again, there's nothing you can't ask, but they should be respectful. As they're a guest in your house, you should be the same way. You should be respectful to them, treat them with respect and courtesy, but again, you need to know. You want to be inquisitive. You want to know. Inquiring minds want to know, and you want to know what's going on. And we talked about this early on. I don't think it's a bad thing to fix something, right? You find a bad power cord or something like that, the strain relief's bad and the jacket's torn and the ground prong's gone. For you to take a pair of wire cutters and cut that off, say this is done, that doesn't mean you admit to the violation. I wouldn't stand up and say, oh, I can't believe we did that. I can't believe that we admit to this violation. But you can say, hey, we want this out of here. You know, if that's a problem with you, we're going to get this out of here. And those things are within reason. But again, for you to act that way shows good faith and says, hey, whatever you're talking to me about, if it's something that needs to be changed, we're willing to take it. And then make sure that the compliance officer follows the safety rules. And again, they are interested in that. They've got a comprehensive safety and health program as well, but they're a guest in your house. They don't always know. So if it's specific PPE or places you don't want them to walk, or you don't walk on lids in the head house, things like that, if you're going to let them know, you're going to make sure they follow to that as well. So if their camera's not intrinsically safe and they're in a class 2, div 1 or 2 area and you don't want them taking pictures, you're going to tell them, hey, you can't do that. So they're going to get the ink pen out and they're going to start making their drawings unless they have the appropriate information or equipment.
So, you know, we've talked a couple of times about how you escort the compliance officer. You know, you don't let them run freely through your facility. You're with them at all times. The point that I like to make is it's not about just being with them. It's that you're leading them. They're not leading you. They tell you what they're there to see, but you decide how you get there. And I've had some silly experiences. In fact, this was an inspection I did with Tom. It's one of my favorite stories, is they were there to look at a powered industrial truck issue. And rather than, you know, taking the guy out to the shop where they're part of the facility where all of our powered industrial trucks were, we drove the truck out to the parking lot and said, have at it. Take a look at this powered industrial truck. If you think there's something defective on here, here it is. And the reason is, as Tom said, OSHA is there to inspect what they're there for. The complaint's just about this issue. But if they see something in plain view from a place they're allowed to be that, you know, is possibly a violative condition, they're allowed to investigate that. So if on the way to where our powered industrial trucks are parked, we walk by a bunch of power presses or a bunch of machines that, you know, there may be guarding issues. There may be, you know, issues with the cords on some of those machines. And I don't want to introduce that issue into the inspection if that's not what the guy is there for. So I might bring the tool to him, or, you know, we've done certainly many instances where, hey, we're here to see some issues in the machine shop. Well, the machine shop's in the back of the house. Let's do a little trip around the outside of the building and come in the back door. They know what you're doing, but they know that that's a right you have, is that, you know, they're there to inspect a specific issue or a specific part of the facility. You take them there however it makes sense to get there. And I like to give a little bit of thought to that in advance. That's one of those pre-inspection tips, is if OSHA comes for a specific reason to see, you know, you sort of break up your facility in different parts. Say, what's the best way to get to this part of the facility? And by the best way, I mean the way that takes them through the least sensitive areas, or the areas that you would least like, you know, some third party to come explore at your facility. So you're escorting, you're leading. It's not just about being with them. And we talked already about for the physical walk around part of the inspection, that's where things like sampling might be done, taking dust samples, taking hearing samples, personal sampling from some of your employees. Ask OSHA during the opening conference if it's that type of inspection. You know, we're going to be looking at combustible dust issues. Say, are you planning to take any samples? If so, you know, I want to plan that so we can do side-by-side sampling with you. If they say one of the issues is hearing loss, hearing protection, you know, ask, are you going to do personal monitoring so we can arrange to do side-by-side monitoring. And I've had, you know, some interesting experiences in the past where we've brought in our own industrial hygienist to do side-by-side sampling, and the results were different, or my industrial hygienist observed the sampling that was being done by the compliance officer and said, that's not a scientifically sound method that this person is using. And we were able to challenge citations based on that. So having that side-by-side opportunity, which you'll only have if you ask those questions and you coordinate with OSHA in advance. Interviews.
We talked about this to a large extent, and I just want to let you know that they're gonna want to do interviews. You're gonna want to arrange those again to minimize your disruption as much as you can. Again, it's a little different than, and I had this question at the break. You know, well, what about if they just come up and want to talk? You know, want to talk to my person, and again, we'll talk about that, the stop and talk versus the interview. It might be, hey, what are you running? What do you normally do? And it's just a real quick, you know, hey, I'm a grinder operator. I'm here all day. You know, because they're trying to identify who they want to talk to. So those might be pretty quick. I would be reluctant to have those interviews, like Eric said, on the floor. I'm going to make a spot where we can do that with them, and we're going to have a pre-selected spot. And again, I'm going to tell them, and so you can facilitate the interview. I don't want you out there. I don't want you exposed to hazard. I want you, you know, focused on what you need to do. And so we're going to bring you up here to have that. They know what you're doing. They when they hand you their phone and when they know how they're trying to manage that, and the seasoned folks will know. So again, the interviews they should be just asking what the normal stuff is. What do you do? How long do you do it? What do they tell you? What's your training? Have you seen programs? What hazards? You got any concerns? Normal things like that. They're going to explain to them their rights under the 11C for discrimination, things like that. Again, you'll need to, if they are reluctant or you are reluctant to let this person go, if they want them bad enough, they're going to give them a subpoena. The subpoena means they're going to find them, they're going to hand them that, they're going to pay them mileage to get to wherever they're going to give their statement, but they're going to be on oath at that point, right? So when it's just a stop and talk, that's not the same. When it goes to the subpoena, it's going to be that higher level. And so again, strategically, you need to determine how far do I want to push and how far do I not want to push, because that subpoena, they're going to have a lot more time to prepare, and it's going to be, usually the lawyers are involved, and it's going to be a little bit different interview. Hourly employee interviews, again, they're going to be looking for that in private. That's going to be their experience through the FOM and what they know. If they want to have union representation, they're going to have that. If the person says, I don't like that person, I don't want them in there, OSHA is usually going to say, sorry, you're going to need to pick another representative or you're going to need to leave. They'll usually manage that up front. That employee representative is not sitting there running the interview for them or answering for the employee. They're there as moral support and to have information, know what's going on. So they'll manage that up front, and they want to make sure that they have that private interview and that they're not creating an appearance of coercion or intimidating the employees, making sure that they know they're fully supportive of being able to do that. And again, you never want to have the appearance of discriminating against an employee because they participated in an OSHA inspection. Bad deal. They don't show up to work 5 days in a row, make sure you did your documentation. They don't get a free pass to do things the way that they want to do them, not your way, because they participated. But you're going to want to make sure your documentation's stout, because in the appearance it's going to be, well, you interviewed this guy and then took action, okay? So make sure you don't discriminate against for that.
So, and we talked about this morning. I want to see if there's anything different on here that we didn't cover. The no impromptu management interviews, that stop and talk concept that Tom was talking about, that's really, from my perspective, limited only to non-supervisory employees. I mean, OSHA does have a right during that walk-around inspection to ask questions of employees. Hey, what's your job title? What do you do here? Those sort of brief encounters. I tend to insert myself into that at about the 5-minute mark and say, hey, listen, this is turning more into an interview. What I'd like to do, and you got every right, OSHA, if you want to interview this person, let's just take it up to the conference room and do it sort of off the shop floor. This is becoming a real distraction, or we'd like to get somebody to backfill this person's job because they're doing something right now, and let's take this interview up to the front of the house. I don't allow that at all for management interviews. There's certainly dialogue, right? If your management person is the inspection representative, they're chatting with the inspector, talking about things at a high level. But the minute it starts to feel like an interview, I say, hey, listen, if you want to interview our safety manager, of course, I expect you're going to want to do that. Let's arrange that the way we talked about in the opening conference. And that's not going to be out here on the shop floor. That's going to be in the conference room. I'm going to be present. We're going to do it like an actual interview. So I don't like to have any kind of impromptu, substantive interview type discussions with my managers, because as I said before, everything they say, it's as though the company is sitting there in the chair speaking those words, and the company is bound by every admission that is made, every statement that is made, every bit of knowledge that is conveyed by that person. The company has that knowledge, and that's going to be used to either establish a violation or possibly willfulness. So you've got to be prepared to manage that discussion with any supervisory employee very carefully. Yeah, and I think that's the gist of it. Everything we talked about this morning.
Just remember, there's nothing off the record either. When you're talking to them, I'm sorry, officer, I was driving poorly. I had 12 beers at supper, but that's off the record, right? If you're talking, they're listening and they're taking notes. So, and I'm not saying it's the Miranda rights, but it's again, they're paying attention. So if you're telling them things, they are absorbing that. That's what they're there to do.
Yeah, and then so the last thing I would say, and this is that you've got an opportunity to prepare witnesses for an OSHA interview. I mean, we made this point back here. Do not coerce, do not intimidate, don't put words in an employee's mouth, don't tell them how they should answer questions, how they're supposed to answer questions, what you expect their answers will be, but you can prepare them, even non-supervisory employees. And there's a few different things that I like to do. By what do I mean by prepare somebody for an interview? One is explain what their rights are. And again, my view of what an employee's rights are do not necessarily align with that discussion that Tom said. The COSHO is going to explain your 11C rights and your rights during the interview. Well, they don't always align, right? There's this big dispute about whether there's a right to a private interview. I'm at least going to go through my version of what their rights are during the interview, try to make them more comfortable with the process. I mean, people sort of freak out when they've got to sit down with somebody with a badge, right? This is a federal agent who's going to interview me, and I'm just out here trying to, load a rail car. It can be intimidating. So part of my process of preparing is to say, hey, listen, they're not inspecting you, they're inspecting the company. There's no right or wrong answers, and let's get you comfortable with this process. You got a lot of rights. You can take a break anytime you want, do all these things. So I like to prepare them for what's the interview going to be like and what are their rights in the interview. Then I give tips and strategy about, hey, always tell the truth. That's one thing that I always tell witnesses. If you're out there preparing employees for an interview, make sure you say that. You want to be able to say, look, I always tell my witnesses, tell the truth. It's literally the only way that a person can get in trouble in an OSHA inspection is by not telling the truth. Everything else is about the company. And the company, they get citations, whatever. You can deal with that. The only way a person can get in trouble is by not telling the truth. Make sure you tell people that going into the interviews. But I give strategies about how to give an effective interview, not about what to say, but how to make it as painless as possible, how to go as quickly as possible, how to get how to answer the questions in a way that, is what they're asking for, as opposed to trying to guess what the next question is going to be, short, concise answers, that sort of stuff is sort of inspection tips. But then the last thing is a substantive preparation. Usually you know why OSHA's there, you know what they're going to be asking questions about. There's no reason you can't say, hey, remember 2 weeks ago when we did our powered industrial truck, refresher training? Here's your signature on that sign-in sheet from that training day. You remember that? I am just astonished in every inspection I've ever participated in how little training employees remember when OSHA asks them about it. It's like no employer has ever conducted training when they sit down with a compliance officer. So I'll go out there and say, look, here's your training record. You remember all these trainings? I'm not putting anything new in their mouths or their minds. I'm just reminding them, hey, we do a lot of training here. You remember we did this, we did this, we did this. And if the inspection is about, I know OSHA's there looking at housekeeping issues, I say, this is our housekeeping program, right? You've seen this 100 times. Do you recognize this? You remember it? You remember, what we say about how often we clean, what the thresholds are? You remember this, right? I'm not teaching them anything new. And if they say, I've never seen it before, I say, all right, well, that's a problem. We're going to have to deal with that. But I'm not going to sort of teach them in the last second what it's about. But there's nothing wrong with reminding somebody what your policies are. If they've been trained in it, you've got records of it, remind them of that, because it blows me away how little training is remembered when they sit down with a COSHO. So that's what when I say prepare for an interview, conceptually, that's what I'm talking about. And it's a balancing act with every different witness. You might have an employee he's disgruntled, he wants to go after the company, he wants to get them good. Well, I still will sit down with that employee and talk about some of this stuff and just remind them, right? I don't want them to go in and say, I've never had training just because they're angry at the employer. I'm going to make it hard for them. I'm going to make it a lie if they're going to try and throw us under the bus for something we did do right. I'm going to remind them they got training. I'm going to remind them we've got a policy, remind them what it is. Even if they're angry, they'll have to think twice about going in and saying some stuff that's wrong just because they're angry. But that's what I mean by prepping for interviews.
Remember on that training, too, from the safety and health side, this is when you got to do it right, because this is when your laundry is going to hit the line. Because they're not going to just say, hey, were you trained? Or what does that training consist of? Oh, the guy threw a video in, played on his phone for an hour. That's not what you want it to be, right? Because they're going to ask that follow-up question. So again, not just are they trained, but what would the training consist of? And I think that's what a lot of folks are going to want to see. So we get to this closing conference again. My way, and I think the intent of the agency and what this was for out of the field operations manual, this is when I sell you my soap, right? This is the hazards I found at your workplace. This is the way you can correct them. This is why it's important to you, right? So I am taking a lot of time as a compliance safety and health officer to tell you how to do this right. Now, I'd love to tell you that happened all the time in reality, and I knew this out of my jurisdiction and everything else. It doesn't always happen that quickly. or that effectively, right? Sometimes it's what I called the swoop and poop. Came in, can't do that. You'll get your stuff in the mail, 15 days, boom, down the road we go, right? And that's some of it's style, some of it's things like that. But again, what they want to know, what you should want to know is I would want to have that closing conference. I want to talk to you about this. I want to know what you found, right? Whether it hits a citation or not. Again, that compliance officer, this is what they're going to be recommending. So I would have that. It might be on the day of the inspection, because it was one real quick thing. It might be 4, 5, 6 months later, right? They have up to 6 months to issue a citation. They'll have a closing before the thing. It might be just a call on the phone. Again, I would want to have that in person. I would want to know what they thought I had issues with. I would want to know what they had as a basis. You know, did you measure that? How high was it? Whatever it was, they should be able to tell you those fact things. Again, I would want to know what they expected out of me for abatement. I would want to know what I needed to do to correct what they perceived was a hazard at my facility. And again, that's that cooperative relationship, and that's that preventative nature that I want to show them that I have. And they usually won't ask you. If you want to ask them, that's fine. Hey, would you classify them as? What do you think the penalty is going to be? They probably won't tell you. They shouldn't tell you, to be honest with you. My role in that was that wasn't my decision, and I wasn't soft shoeing that. But there was a lot of things that needed to take place before I got there, right? So I wanted to let them know what those hazards were, and then what I wanted to see them fix out of that, and how long it'd take to fix that. So that was the discussion we'd have on the closing conference.
Yeah, I mean, from my perspective, I talked about the opening conference being a really significant moment in the inspection. I think the opposite is true of the closing conference. I think this is probably the least important part of the process. You're going to, listen, hear, take notes about what the agency's findings were. It's not an opportunity to try and advocate for an item to be withdrawn. Say, oh, I think you got it wrong. If there's a really obvious misimpression that the agency had, for example, they'll say, hey, so, we're going to recommend a citation here for failing to, conduct training. You say, well, wait a second, I don't remember you asking for training records during the inspection. We do training. If that's an impression you have, can you hold off for a couple days? Let me get the training records to you. Sometimes that's useful, sometimes it's not. If it's just a really obvious sort of black and white sort of thing, we're going to issue a citation for not having something that exists. You might ask for a little bit of time to supplement a production from earlier in the inspection, but otherwise it's really just an opportunity to listen, ask questions, as Tom said, and try to start to prepare for informal settlement conference, start to prepare for a defense of the citations, not really a time to start to advocate. Citations are issued generally, as Tom said, there's a 6-month statute of limitations. There's some weird nuance around that, but as a general rule, it's 6 months from when the violation occurred. Usually in practice, that means it's 6 months from when OSHA started its inspection, citations will arrive. And the other thing to think about, we talked about the enforcement press releases, is you should start to prepare for that. After a closing conference, the citations are coming soon. They're not going to tell you what the penalty is. They're not going to tell you how they're characterized, but you can get a sense of, is this going to be a doozy or not? And if it's a doozy, there might be a nasty press release coming with it, so start to prepare for that. Think about whether you've got, want to implement your own PR strategy to put out your own response to that. You don't want the press cycle to go multiple days on this thing, so you want to think about it. If there's a citation and a press release, I want to have a statement ready for that day so that both sides of the story are told, and hopefully that's the end of it and there's no more press coverage about it. But that's one of the things to think about around the time of citations. We've got a whole bunch of slides in here, like 20 slides in here about what your options are, what to do after the fact, but we really mainly wanted to focus on the inspection itself, and I think time-wise we're getting pretty much to the end here. I'll just make this one point here about post-citations. I said earlier, you've got a right to challenge citations if they're wrong. This is generally the where's the one about that? Yeah, this is the slide I like to talk about. It's important. These are at a high level, these are basically your options. You can look at the citation and say, all right, get my checkbook. Let's write the check and send it into OSHA. In my perspective, that is never the right option. There is basically a process here, this informal settlement conference, that's almost like the SAT. If you show up and spell your name right, you're going to get some points. And so it is almost never the right thing to just pay the fine and close that matter for your purposes. Always sit down with the agency. If for no other reason, it's an opportunity to build a relationship with the agency. That agency is going to be your regulator tomorrow once this citation is resolved, whether it's resolved through litigation, through an informal settlement conference, or just by writing a check. So get to know them a little bit. Show them that you're interested in safety. You know, show your good faith and start to get to know the personalities in your among your regulator. So at the very least, I would always engage in some level of discussion with the agency, maybe get some penalty reduction, maybe you get a change in the characterization, or more importantly, you get some real fundamental changes to the citations. You can request a variance if the violation seems legitimate, but the abatement is impossible or there's some better way to do it. But I would say this is almost impossible to get a variance. There's something like 12 active variances on the books from the last decade or more. So this is not likely an opportunity to pursue, but technically the option is out there. And then the other two major the options that are really utilized by employers and I think are worth pursuing is the informal settlement conference, where you might actually be able to resolve the case right there with the area office, maybe without even getting a lawyer involved, although we're pretty good at informal conferences too. Or you file a notice of contest and you negotiate over a settlement, a formal settlement agreement after the contest is filed. We found that you can tend to get better results when you go just a little bit further into the process, contest, negotiate with OSHA's lawyers. You might get more relief than you might get just at the informal conference. Or if need be, and there's a compelling reason that you must have this citation off your record, OSHA's got it wrong, but they're just not hearing you. They take a different interpretation of a standard and you think you've got it right, and it's going to have a pretty significant impact on your business. You can follow it all the way to a hearing, and there is a separate body of independent judges who decide whether OSHA got it right. You're not presenting your case to OSHA, you're presenting it to the OSHA Review Commission, and they are truly independent judges. So again, OSHA is not the final word, and there's lots of opportunities to correct things when there's a mistake made. That's it.
I think that's the end of our time. So thanks a lot for having me here. Be glad to help you if you need have specific questions that we haven't covered in the session. See us afterwards, and we'll make sure we can go through those with you. And again, appreciate your time.
Tom and Eric, thank you very much. Excellent presentation, and I know one question that always keeps coming up at every single meeting, even after all these years. I always get the question, where do the fines come? Where do the fines go? You issued a citation from OSHA. It's a fine. Where does the money go? Does the money go to OSHA? No, the money does not go to OSHA. It goes to the U.S. General Treasury Fund.
It goes
right?
to Kim Stilley, right?
Yeah.
There's
No,
a resort.
all of that. It's not a user fee. I have to remind everyone. It's kind of everyone thinks OSHA gets it. It's not. It's not a user fee. It's a penalty, and it goes to the General Treasury Fund. So just as always a reminder when there's questions about that. But anyway, I want to thank everyone for